Mpumelelo Zikalala, a legal analyst. Thank you very much, Mr. Zikalala, for your time this afternoon. So, Mthokozisi Thwala, since the death of his friend, has made 4 statements. He's never written a single one of those statements. He remembers a particular incident in 2017 where he was fresh from work, taken to the beach, and relayed what happened to the specific police officer who wrote down the statement. But he also signed for all 4 of these statements that he has never written, but actually orally relayed the information. Is this unusual?
No, it's not. You'd find that in a lot of investigations, statements are going to be written by the police themselves, and it would be read back to the person who's making the statements. And if you do agree with it, you will then be able to sign it and initial every page. Now, there's no defense in hiding to the fact that I did not write the statement. This is how things are supposed to be. Because at the end of the day, it's one of the things which are poked at by the defense in terms of saying, but you're under oath under this statement, you are changing the manner in which you're giving your evidence here. So which one should we agree to, or which one should we believe? Especially if you're going to be a witness that comes after other witnesses have already testified. So it does dent a bit the credibility of the evidence that you are coming with, but you're able to repair it from the side of the state through a re-examination if it needs to be. It's a train smash, but not that much of a train smash. It can still be fixed at the end of the day if they show that there's consistency in the manner in which the witness is giving evidence.
9 years and 4 statements later, is it unusual that the state would then require somebody to make 4 statements?
It would be. You would find that there would be only one investigating officer that is there. And then once they've talked or discussed this matter with anyone, unless there are issues of clarity that would need to come and make, then that would suffice. I think maybe 2 would be enough, but to make 4, it means that certainly it's either the IO was not really sure as to how they would go about investigating the matter, or there were certain things which were so conflicting to such an extent that they needed to come time and time and again just to check the veracity or whether the sequence of events as relayed by the witness are indeed actually true. Another indication may mean that he may sometimes, depending on the circumstances of each matter, have even been part of the list of potential accused persons. So it does tend to say, why engage in this particular manner? I think the IO would be best to answer that question in terms of asking him, why did you go time and again to this witness? What was so glaring or what was so conflicting or information which was missing, which necessitated you to come back 4 times to come with the same witness and to ask them to repeat the sequence of events that happened on that day?
You mentioned that the defense poking holes in the statements in terms of inaccuracies that are contained in the statement and the witness's testimony in court is actually going to boost the defense's case. The defense also, Advocate Ramusipidi, pointed 3 occasions where this particular witness, Mthokozisi Thwala, was sharp. A book that was written that contained inaccuracies where he read it over 2 days and even gave feedback to the author of the book. There was one particular incident in Pietermaritzburg where he refused during the identity parade to implicate somebody that was not in the house. And the 3rd incident where a certain officer, Buthelezi, wanted to put words in his mouth and he refused, basically trying to draw or rather point our attention to the fact that this is somebody who's sharp. So why would you allow for inaccuracies to be contained in a statement that implicates you directly?
Basically, I was saying to him, you've constantly displayed actions or signs of someone who does not want things which are inaccurate to be relayed as coming from you. So what has changed up until now? And if there are certain changes that have taken place, are you, as we are speaking now, relaying the same information, or are you going to come back at a later stage and say that you have made a mistake? It is not what you intended to state. The words were twisted out of your mouth. So I think that's what we're trying to make initially. On the second stance, I think he may be laying a background of saying to the IO that is going to come in, if the investigating officer is indeed called, then the question becomes, in the manner in which you've investigated this matter, you've tried to implicate so many individuals to such an extent that you are even drawing inferences and forcing people to admit things which are not correctly true. So the 5 accused that you have in front of this court may not be individuals or perpetrators that were there on the day. It may mean that there were certain easy targets, or there are certain things that pointed off to them, and it was easier for you to say, these are the individuals which I'm going to bring to book for this particular crime, and the real perpetrators are out there. So I view it as being twofold. First of all, You're trying to discredit the information or the evidence which is going to be provided by this witness. Secondly, you are laying a foundation of the certain questions which you are going to ask at a later stage about the methodology which was used in the investigating of this case, and part of it, or the motive being, you've got the wrong individuals sitting in the accused box, the real perpetrators are out there, and due to the shoddiness in the manner in which you've investigated this matter, that's why you have the incorrect results. Has
the matter been shoddily investigated?
There are certain things which are missing. I think at the start, or the manner in which it's being investigated, at the start it's okay, but when it comes up to tying up what has been investigated with the individuals that are in the accused box, then you find huge problems. Problem number one, why didn't you fuse the two dockets that were out there? It's the same matter, same sequence of events, same person was murdered, same type of witnesses. Take those two dockets, mesh them together, see what works for you, and exclude what does not work for you. In the exclusion of that, see which individuals are lying so that you can charge them with perjury, so sort of teach members of the public a lesson that if you lie under oath, you are going to be prosecuted. Second one, when it comes to cell phone evidence that has been recently introduced, show the motive that says the manner in which these particular individuals were communicating. They were concocting something, or there was something behind the scenes which was being done, hence the motive of why the particular incidents took place. So if you are going to stick to a robbery gone wrong, stick with that. However, if you are going to say there's another motive that was the premeditated murder, for example, that is there, prior communication with the individuals, then be able to show the part. Don't introduce evidence and just leave it hanging, unless at a later stage you are going to come back and be able to fuse it in and show us the bigger picture. I always explain it like this. It's like you're piecing together pieces of a very big puzzle, and each piece in which you take to put it in that big piece has to be dusted off, being investigated, be cross-examined, and if it fits, it's going to form part of the puzzle. If at the end of the day there are holes which are missing in that bigger picture, the court will have no choice than to acquit the individuals that are there. But if the pieces of the puzzle fit in perfectly and they make a bigger picture which is coherent, is able to be shown, and most importantly has motive of why a particular act was done, then the court will come to the conclusion of saying that the accused that are there are indeed guilty.
The seemingly long-winded approach of the state, can the judge intervene and actually call for the people that were in the house, right, to what you have just said? Given also the time, maybe not constraints, but how he's gone on to stress that this has taken too long.
Now, let's remember that the role of the judge is that of the presiding officer. He needs to go and judge this matter, to arbitrate on it and say what is wrong and what is correct. The only thing in which he can deal with is the information that has been submitted to him. He's not the prosecutor, so he's not going to go and ask for evidence to be brought in, but he may ask for instances of clarity on the evidence that has been brought in. So he can't dictate as to how the prosecution is supposed to do its case, in the same manner in which he can't dictate how the defense is supposed to do its case. But what he can do is to say, whatever has been presented to him, let me make sure that I'm able to clarify certain instances in which I may have questions in, so that when I adjudicate at the end of the day, I adjudicate properly. What he has been doing correctly, though, is to say, I'm not going to waste any time. I'm going to use all the allocated time in this matter effectively. And when it comes to any unreasonable instances of breaks which are not supposed to be there, witnesses not being available, and time which is lost, which is crucial, I'm not going to tolerate that for two reasons. Firstly, I need to make sure that as per the Constitution, that the matter starts and ends within a reasonable amount of time. And then secondly, I'm looking out for the victims in this case. It's been 9 years since this matter occurred. I do not want the quality and the quantity of the evidence to diminish purely by the passage of time. So I need to get it as soon as possible so that I'm able to adjudicate this matter.
Very quickly for us, Mpumelelo, Mthokozisi Thwala mentioned something that I guess maybe we should all pay attention to, because he said, before this I never had to deal with the law. So when it comes to the issue of statements and the police writing them for you, what is it that citizens need to know? Do you have a right, or can you insist on writing those statements for yourself? And where are we with digitizing such processes? Because here we have a case of so many inaccuracies. Well, I'd never said that, or the person writing that statement misunderstood this, or this is not what I wanted to say, or he drew his own conclusion.
You must remember that you're going to be alone in the witness box when you're being quizzed about it. And the last thing that you want to do is for you to be branded as a person who is a liar, who is deceitful. So it's always advisable to then say, even if it has been written for me by the presiding officer, can I go with it with the fine form? I'm going to delete whichever is not applicable, and I'm not going to simply accept what has been written about me on it. Now, it may present certain issues when it comes to illiteracy and people who cannot read or write because they are not able to do that. But moving on with the times, there's nothing stopping us from doing depositions or affidavits which are done, or pre-recording of whatever that is being said, together with what has been written down, so that if there are any instances of any disagreements of what exactly has been said, you can always draw those recordings, come and put them here, and be able to adjudicate on those matters. All that you need to do, amend the Criminal Procedure Act, put in preventative measures to stop any type of interferences with that evidence, and certainly it's going to assist with us. But if we exclude the development of technology in the manner in which we do things in our court, will forever be stuck with these type of problems and not being able to move forward.
Thank you very much. Mpumelelo Zikalala is a legal analyst.